Good evening. Good evening, ladies and gentlemen. My name is Davide Rodogno. I'm professor of international history here at the Graduate Institute, and I would like to present the artwork project called 70 and say a few words about it. A few months ago, Robert Roth, who is here somewhere, yes, up there, and I decided to convene a workshop intertwining juridical and historical approaches on the study of human rights with a focus on the Universal Declaration of 1948. And in a few minutes, Philippe Sands public conference will mark the culmination of an intense day of work and of scholarly exchange and dialogue. Now, in a few months, more precisely in June 2019, we will celebrate yet another anniversary, the 70th anniversary of George Orwell's novel 1984. The Universal Declaration of Human Rights and 1984 have been two texts of great significance in the second half of the 20th century, and I believe beyond it. Two texts of radically different nature, of course, but they do have something in common. They have inspired many people who fought and still fight for justice and freedom around the world. What would happen if we were to combine these two texts? What shape would take a reflection on the past, present, and possible futures of these two texts? And how contemporary art in its broader manifestations or pop culture might connect human rights with the issue of denial of the most basic, fundamental freedoms? How would art and culture experience and connect with these issues of crucial importance to all of us? The International History Department of the Graduate Institute associated itself with Utopia 3, a Geneva association with the aim of exploring these themes, their most obvious, surprising, or completely unexpected interconnections and mediations. And tonight, we are delighted to show you a teaser of the program that awaits you in late 2019, and this is just an avant-goût.
Universal Declaration of Human Rights Preamble. Whereas recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world, whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of common people, whereas it is essential, if man is not to be compelled to have recourse, as a last resort, to rebellion against tyranny and oppression, that human rights should be protected by the rule of law, whereas it is essential to promote the development of friendly relations between nations, whereas the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the human person and in the equal rights of men and women, and have determined to promote social progress and better standards of life and larger freedom, whereas member states have pledged themselves to achieve, in cooperation with the United Nations, the promotion of universal respect for and observance of human rights and fundamental freedoms, whereas a common understanding of these rights and freedoms is of the greatest importance for the full realization of this pledge. Now, therefore, the General Assembly proclaims this Universal Declaration of Human Rights as a common standard of achievement for all peoples and all nations, to the end that every individual and every organ of society, keeping this declaration constantly in mind, shall strive by teaching and education to promote respect for these rights and freedoms in life.
and we left you wondering. So without further ado, I invite my colleague Paola, Gaeta, and Philippe Sands to join here at the podium so that Philippe can be properly introduced by her. And I wish you a very pleasant evening in company of Philippe and Paola. Thank you very much.
So you have a seat there. So good evening, everyone, and it's my pleasure to be here and to have got the privilege to introduce to you to an exceptional speaker, Professor Philippe Sands. I just want to say that this event, this conference, ends a full day where the organizer of the Department of International History and the Geneva Academy of International Humanitarian Law and Human Rights have organized to celebrate the birthday, the 70th birthday of the Universal Declaration of Human Rights. So we conclude this day of discussion with this conference by Philippe Sands, and I'm supposed to say a few words to introduce him to you, although I really think that he does not need any introduction. So I just would like to say that in the description of his biography, short biography from the organizers, flyers, I could read that he's professor of law at University College of London, a practicer barrister at Matrix Chamber, that he appears as a counsel before many international courts and tribunals, including the International Criminal Court and International Court of Justice, that he's also an arbitrator, and is the author of many books, including, and some of them have also received very important prizes, and I will come back to this in a moment, and he's also contributed to New York Review of Books, Vanity Fair, the Financial Times, and The Guardian. So this is a very short biography that I don't think gives justice to the personality of Philippe Sands, because indeed he combines not only the academic career, but also a practicing career, and is an artist because he's the author of books that, as I said, have received prize. His most recent book, EastWest Street, has received already 5 prizes, if I counted them well, Philippe. And I understand that at this time in Brussels, his daughter is receiving the Prix du Livre Européen, and they decided, nonetheless, to come here instead of getting his prize. So I thought it's better than Bob Dylan, and also he sent his daughter, at least, to get this prize. So we are very happy to have him today with us. And I also had a look at his schedule from the university UCL. There is the schedule of his forthcoming events, and I wonder, how do you manage, where do you find all this energy to do all you do? And without further ado, I'm happy to give you the floor, and we look forward to your presentation. Thank you very much, Philippe.
Thank you very much. Okay, yep, the slides will go on. Excellent. Well, thank you, Paola and Davide, for the invitation and the very nice words. I'm frequently in Geneva, and it is incredibly nice to be back and to see many friends in the audience. You've had a rather full day on the legacy of what happened on the 10th of December, 1948, 70 years ago, when the Declaration on Human Rights was signed, a declaration that is today part of the baggage of modern international law. Each of us has baggage. I long ago came to understand that my own various activities, teaching, writing, litigating, are engagements, each of which are informed by my background, by the baggage that was attached to me when I entered this world, as each of us has our baggage. I was not a blank slate, and none of us are blank slates. In his very fine autobiography, the historian Eric Hobsbawm recognized that complex connection between who we are and what we do. He noted a profound interweaving of a person's life and times, and the understanding and observation of each how that helps us to shape historical analysis. I'm not a historian, I'm a lawyer, and I'm a lawyer who focuses on matters international. My professional and academic interest is a desire to understand how the law functions, how it works, how rules come into being, how they're interpreted, how they're applied, how they affect the behavior of international actors, from individuals and groups to governments and states. My curiosity about a person's life and times concerns the way it might inform the world, and the experiences of the past quarter of a century in the work I've been fortunate to do, not least in courtrooms, appearing before many international judges from so many different backgrounds, points to a rather clear conclusion. Individual lives and personal histories really matter, and they really can make a difference. The book that I wrote, EastWest Street, on the origins of genocide and crimes against humanity, took nearly 7 years to write, and it's not about the life of one person, but 4 people, 4 individuals. The book tries to understand how the particular circumstances of each of those 4 individuals contributed to the road each of them took, and how the different roads they took then changed the system of international law that is my daily work. But as many of you know, the book touches a much more personal theme, how these 4 interweaving lives influence the path that I've taken, whether directly or indirectly. And below that personal theme lurk some pretty big questions, questions that touch each of us and which will be of interest to each of us in different ways in this room, central questions of identity. Who am I? How do I wish to be defined? Principally as an individual or as a member of a group? And if so, which group or groups? How do we want the law to protect us? Do we want it to protect us as individuals or as members of a group? These questions are as pertinent today, perhaps even more so, as they were when the legal concepts of crimes against humanity and genocide were coined back in 1945, and as they were in December 1948 in Paris, when the Universal Declaration on Human Rights and the Convention on the Prevention and Punishment of Genocide were signed at the Palais de Chaillot. In a way, EastWest Street came about entirely by chance, as does so much in life. It was the spring of 2010. I was immersed in my world of classrooms at University College London, of academic articles, of cases in The Hague. An invitation arrived, and the person who procured that invitation is in the room today, and I express my deep thanks for making that happen. An email from the law faculty of the university in a city that used to be called Lemberg during the Austro-Hungarian Empire until 1918, and then became Lwów during the Polish years until 1939, and then after 1945, Lviv. Would I come and visit and deliver a public lecture on my work on crimes against humanity and genocide? The email inquired. Would I talk about the cases in which I have been involved, about my academic work on the Nuremberg trial, and about the trial's consequences for the modern world order? Yes, I said, I'd love to come. I'd long been fascinated by the trial and by the myths of Nuremberg, the words, the images, the sounds. The trial was, of course, catalytic in many ways. It was a moment in which our modern system of international justice, such as it is, catalyzed into being. I was mesmerized by the trial, by the tiny points of detail you've spotted in the lengthy transcripts, by the terrible evidence. I was drawn to the books and the memoirs and the diaries that described in forensic detail the testimony that was laid before the judges, but touched far more lightly on other matters, like the love affairs that went on behind the scenes. I was drawn to films, like Judgment at Nuremberg, which won an Oscar in 1961. So memorable was the speech by Spencer Tracy and his momentary unexpected flirtation with Marlene Dietrich, culminating in his final judgment. We stand for truth, justice, and the value of a single human life. I don't think any international judge has put it better than Spencer Tracy. There was also a practical reason for my interest, because the trial's effect on my work had been profound. The Nuremberg trial and judgment blew a powerful wind into the germinal sails of the human rights movement. Undoubtedly, there was a strong smell of victor's justice, but the case was totally catalytic. It opened up the possibility that the leaders of a country could be put on trial before an international court. And that was the first time in human history that it had happened. It must have been my work as a barrister rather than my writings, perhaps, that caused the invitation finally to be sent from Lviv. For in the summer of 1998, I'd been peripherally involved in the negotiations in Rome, working actually, he's not here tonight, with my dear friend Andrew Clapham, which led to the creation of the International Criminal Court, a body that would have jurisdiction over both crimes against humanity and genocide, as well as two other crimes. The essential difference between the two is on who is protected and why. Assume that 10,000 people are killed, murdered, exterminated. The systematic killing of such a large number of individuals will always be a crime against humanity, but will it be a genocide? That depends on the intentions of the killers and the ability of prosecutors to prove those intentions. To establish the crime of genocide, it is necessary to show that the act of killing is motivated by a special intent, namely the intent to destroy a group in whole or in part. If a criminal prosecutor cannot prove that a large number of people have been killed with that intent, then the crime of genocide under international law is not established. And so you have these two crimes operating side by side and sometimes overlapping. Every genocide will also be a crime against humanity, but not every crime against humanity will be a genocide. A few months after both crimes were inscribed into the statute of the ICC, Senator Pinochet was arrested in London on charges, interestingly enough, both of genocide and crimes against humanity, laid against him by a Spanish prosecutor, Baltasar Garzon. The House of Lords ruled that even as a former president of Chile, Pinochet was not entitled to claim immunity from the English courts, and that was a novel and totally revolutionary judgment. In the years that followed, the gates of international slowly creaked open after 5 decades of relative quiescence during the Cold War chill that followed Nuremberg. Cases from the former Yugoslavia and Rwanda soon landed on my desk in London, and others followed, relating to allegations in the Congo, Libya, Afghanistan, Chechnya, Iran, Syria, Lebanon, South America, Palestine, Israel, Sierra Leone, Guantanamo, and Iraq. These were based on the new rules that came into being after 1945, a revolutionary moment in the making of modern international law, when it was recognized that the rights of the sovereign over its people were no longer unlimited. The long and sad list of cases that reached my desk reflected the failure of good intentions in Courtroom 600 of Nuremberg's Palace of Justice. I became involved in many cases that involved mass killings. Some raised claims of crimes against humanity, the killing of individuals on a large scale, and others gave rise to allegations of genocide, the destruction of groups. Two distinct crimes, with their different emphases on the individual and the group, grew side by side, although over time, genocide seems to have emerged in the eyes of many people as the crime of crimes, a hierarchy that leaves the suggestion that somehow the killing of large numbers of people as individuals was less terrible than the killing of them as members of a group. Occasionally, I'd pick up hints about the origins and the purposes of the two terms and the connection to arguments first made in Courtroom 600. But I never really inquired too deeply as to exactly what had happened at Nuremberg. I knew generally how these crimes had come into being and how they subsequently developed, but I knew very little about the personal stories behind them or how they were even argued at Nuremberg, and the invitation from Lviv gave me a chance to do some research on those stories. So I could say that I made the trip to Lviv to give a lecture, but that would not be true. I travelled for another reason, and it was this reason. My grandfather, aged 10 years old, who was born in the city of Lviv in 1904. His name was Leon Buchholz, and when he spoke in German, he called it Lemberg, and when he spoke in Polish, he called it Lwów. In his wonderful, slim volume, the Polish poet Joseph Witlin, called Mój Lwów, My Lviv, published in 1946 and now available for the first time in English, published by Pushkin Press as The City of Lions, Witlin describes the essence of being a Lwovian. It is, he writes, an extraordinary mixture of nobility and roguery, of wisdom and imbecility, of poetry and vulgarity. Nostalgia, he continues, likes to falsify the flavours, telling us to taste nothing but the sweetness of Lwów today. But, Witlin concludes, I know people for whom Lwów was a cup of gall. And it was a cup of gall for my grandfather, Leon. Buried deep, it has to be said, part of a hinterland of which he never once spoke to me. His silence barely covered the wounds of a family that he left behind in 1914 when he moved to Vienna and then lost forever after 1939 when he moved to Paris. The moment I set foot in the city of Lviv in the autumn of 2010, it felt familiar. It was like meeting a long-lost relative. It was as though the dark DNA of the city was part of me. I had missed it, and somehow, and I've gone back every year now, sometimes twice and even 3 times, I felt incredibly comfortable there. Why I had that reaction caused me to explore psychoanalytical writings that address the relationship between grandparent and grandchild. And I was directed in particular to the work of 2 Hungarian psychoanalysts, Maria Torok and Nicholas Abraham. What haunts, they wrote, are the gaps left within us by the secrets of others. And those are the words with which EastWest Street opens. My grandfather Leon's secret was that he came from a huge family, one that was centred in Lemberg and its environs. He had literally dozens of uncles and cousins and nephews and more distant relatives. It was a large family and it continued to grow until 1939 when war returned to the city. But within 6 years, by the spring of 1945, he was the only member of that Lwów family still alive. He was the only survivor from the city and from the district of Galicia. He was lucky to get out. He went to Vienna when the Russians took the city in 1914, and 25 years later, he was expelled from his new country because of his religious affiliation. He went to Paris, and he was there as a Frenchman, living when I came to know him, when I came into the world. Amongst his many papers, I found one that I'd never seen before, an expulsion order. Translated into English, it says, rather brutally, the Jew Buchholz Morris Leon shall leave the territory of the German Reich by December the 25th, 1938. And the reason he could be expelled was that he had been made stateless by an earlier law. That, I'm sure, is one of the reasons that I feel as strongly as I do about the current fad in some countries, including the United Kingdom, to strip certain people of their nationality. One thing leads to another. I had always assumed that my grandfather Leon had left Vienna with his wife, Rita, my grandmother, and his one-year-old daughter, Ruth, who is my mother. But in the course of the research that I did in preparing to go to Lviv, I discovered that this wasn't the case. And I think it was this central fact that lay so deep and which touched on the silences in our family and in my childhood. Leon left Vienna and made his way to Paris by himself. Only now, gaining access for the first time to his personal papers, as I prepared the lecture for Lviv, did I learn that his daughter had travelled to Paris a few months later, after him, and that his wife, my grandmother, remained in Vienna for 3 more years. From this, I formed a sense that something must have happened, that intervened in their lives before the three separated in January 1939. Why did Leon leave Vienna by himself? How did my mother get to Paris by herself, aged less than 1? And why did my grandmother stay behind in Vienna? How could she, as a mother, bear to be separated from her only child? These are all big questions, and they hung in the air as such questions tend to do once you've asked them. I returned to the documents found amongst my grandfather's papers, and I was looking for clues. And it was helpful here to be a litigator, which is a sort of lesser amateur historian come psychiatrist. You learn that every piece of paper, every photograph, is capable of holding information that is not immediately knowable. It's the muck of evidence, and I love that muck. I've learned to look carefully, keep an open mind, attend to unexpected possibilities, find the dots, try to persist, and never give up, because nothing is ever quite what it seems. 2 items stood out. One was this small scrap of thin yellow paper. It looks large here, but actually it's only about 1.5 centimetres by 2 centimetres. One side was blank, and the other bore a name and address written firmly in pencil. The writing was angular and strong. Miss E.M. Tilney, Manuka, Bluebell Road, Norwich, Angleterre. The second item was a small black and white photograph, no larger, taken in 1949. It showed a middle-aged man staring intently into the camera, a faint smile across his lips. He wears a pinstripe suit, white handkerchief neatly folded into his breast pocket, and a white shirt. He's got a polka dot bow tie, which sort of emphasizes a slightly mischievous air. On the back of the photograph, written in blue ink, it said, Herzliche Grüße aus Wien, September 1949, warmest wishes from Vienna. And there was a signature in a firm but indecipherable writing. When I first saw these items, I asked my mother about them. She said she didn't know who Miss Tilney was or the identity of the man in a bow tie. But the scraps were retained. Perhaps they might shed some light on what happened to my grandfather in 1939. So I pinned them on the wall above my desk, and there they remained for 4 years. And I turned to the lecture that I had to write. I've taken you off on a sort of little personal detour, but you'll recall the lecture that I was due to give in Lviv was on crimes against humanity and genocide. So let me take you to the first of several coincidences. In preparing that lecture, back in the summer of 2010, I was immensely surprised to learn that the man who put the concept of crimes against humanity into international law actually came from Lviv. Indeed, he was a student at the very university that had invited me to deliver the lecture, although those who invited me were not aware of the fact. His name was Hirsch Lauterpacht, and he'll be very well known to many of you in this room. He was actually born in a nearby small village of Żółkiew, about 15 miles to the north of Lviv. Today it's called Żółkwa in Ukrainian. He moved to Lviv when he was 14 in 1911. He enrolled at the university law faculty 4 years later. In 1919, he moved to Vienna and became a student of Hans Kelsen's, where he studied international law. He came to the United Kingdom in 1923 with a new young wife, Rachel, to study. He became a renowned academic, first at the London School of Economics and then at Cambridge University. And in 1945, he published a book that contributed to the foundations of the modern system of human rights and to the Universal Declaration. He gave it the title, An International Bill of the Rights of Man, and it was, in 1945, totally revolutionary. His idea was that every human being on the planet had rights under international law simply because they were a human being. That did not exist as an idea at that time. He prepared draft articles, 20 in total, which covered much that was new, but certainly not exhaustive. It's worth having a look at it. By more contemporary standards, there are striking omissions. There is no reference to any prohibition on torture or cruel treatment. There is no obligation not to discriminate, for example, against women. And equally striking was his approach to the situation of non-whites in South Africa and what he called, and I quote, the thorny problem of actual disenfranchisement of large sections of the Negro population in some states of the United States, end of quote. That was how he put it, a brutal recognition of realpolitik necessary to allow those two countries to engage with his international bill. Sometimes less is more. In any event, the draft bill gave effect to his credo that the individual human being is the ultimate unit of all law. And if there is anything to mark in relation to the 70th anniversary, it is that idea. Those words, I suspect, will have a certain resonance in this room. In April 1945, after the war in Europe ended, Churchill, Roosevelt, and Stalin agreed that there would be a criminal trial for senior Nazi leaders, and the British hired Lauterpacht to assist in the prosecution, to work with Robert Jackson, the chief prosecutor. In July 1945, Jackson travelled to London to draft the charter for the Nuremberg Tribunal. The four powers, America, France, Britain, the Soviet Union, couldn't agree over the list of crimes which the tribunal would exercise jurisdiction over. Jackson turned to Lauterpacht for help. On July the 29th, Jackson left his room at Claridge's Hotel in Mayfair and was driven with his son up to Cambridge to spend a day with the Lauterpachts. They sat together in Lauterpacht's garden on Cranmer Road. This is that garden, and the photograph was taken in that year. Jackson and Lauterpacht talked about the problem of the list of crimes. It was Lauterpacht who had the idea of putting titles into the charter. He thought it would help public understanding and give legitimacy. Jackson reacted positively to the idea, so Lauterpacht offered another on the subject of atrocities committed against civilians. This was a matter on which the Americans and the Soviets were deeply divided. Lauterpacht had, of course, a long-standing academic interest in the topic, but there was also a deeply personal interest. He had no news about his family, his mother, his father, vast family like my grandfather's, in Lemberg. As a sort of emerging Englishman, he said nothing to Jackson about any of this. Why not, he said to Jackson, refer to the atrocities committed against civilians as individuals, as crimes against humanity? You can see here the words in his own hand. The term would cover atrocities against individuals on a large scale: torture, murder, disappearance. It would be a totally new concept in international law. Never before had a legal concept instrument used the term. Jackson liked the idea, took it back to London, and a few days later, crimes against humanity was incorporated into the Nuremberg Charter as Article 6, paragraph C. Clearly an innovation, Lauterpacht told the Foreign Office, but one that reflects an enlightened conception of the true purposes of the law of nations, a part of the law of mankind which signifies that those who violate international law cannot hide behind the concept of sovereignty. Preparing the Lviv lecture required me also to focus on a second concept, genocide, and this brings me to a second surprise. The man who invented that word, literally invented it, in 1944, also spent time in Lviv and also, by amazing coincidence, studied at the same law school as Hirsch Lauterpacht. His name was Raphael Lemkin. He arrived at Lviv University in 1921, 2 years after Lauterpacht left, and he remained there until 1926, when he obtained a doctorate in criminal law. The people who invited me to Lviv were actually unaware of his connection to the university. He was born 500 kilometers to the north and moved there in 1921. When he left, he became a public prosecutor in Warsaw. In 1933, he wrote a pamphlet for a League of Nations meeting in Madrid proposing a new international crime, barbarity and vandalism against groups of people. His focus was not on the protection of individuals like Lauterpacht, but on the protection of groups, sometimes referred to as minorities. His ideas bounced around, but nothing came of them, and the timing was hardly ideal. Hitler had just taken power in Germany. In 1939, when Germany invaded Poland, Lemkin was in Warsaw. He escaped, made his way to Sweden via his parents' town of Volkowisk, which by then was under Soviet control, and in 1941 left Stockholm for America. As Europe was closed, he travelled the long route across the whole of Russia to Japan, by boat to Seattle, then by train to Durham, North Carolina, where he had been offered refuge as an academic. He travelled with virtually no money, totally impecunious, and no personal belongings, but a huge quantity of luggage. That luggage was filled, literally, with thousands and thousands of pages of paper. He had spent a few months collecting the decrees which the Nazis had promulgated in the countries of occupied Europe. He gathered these materials, carted them 3/4 of the way around the world to the United States, analysed them, and, having been offered a book contract in 1942, described the pattern of behaviour he had found, looking for an underlying master plan. The book was published in November 1944 with the title Axis Rule of Occupied Europe. And chapter 9 of the book had as its title a completely new word, genocide. Lemkin's invention, the crime of the destruction of groups. The Nazi master plan, an amalgam of the Greek word genos, meaning tribe or race, and the Latin word side, meaning killing. You can see the words here in Lemkin's own hand. In the summer of 1945, Lemkin was hired by the US government, and he worked with Jackson, amazingly, although on a different team, separately from Lauterpacht. He pushed his idea of genocide. That was the crime that he wanted the senior Nazis to be indicted for, the destruction of any group, and he mentioned Poles, Roma, Jews, was a matter for the Nuremberg tribunal. It was, in his view, the greatest and most terrible of crimes. In August 1945, when the Charter was adopted after Jackson's visit to Lauterpacht, Lemkin was hugely disappointed that it included crimes against humanity on the protection of individuals, but made no mention of genocide. It was totally silent about the destruction of groups. He believed it should have mentioned genocide. But all was not lost. The Charter was, in his view, broad enough to encompass the term. He flew himself to London, where the indictment against individual defendants was being prepared. He fought his corner as Jackson's team prepared the indictment, working with the British, French, and Soviets. Lemkin was persistent. He drove people crazy, actually, and pressed actively for genocide to be included. There was very strong opposition to the concept of genocide from Jackson's office under pressure from southern US senators who were concerned about it being invoked by African Americans in the US, and strong opposition from the British who were concerned about the legacy of colonialism. But against the odds, the word made it into the indictment, and Lemkin was greatly pleased. In early October, the four powers agreed the final text of the indictment, and genocide was included in count 3 on war crimes, the ill treatment and murder of civilians in occupied territories, including Lemberg and Volkovisk, where his parents lived, although, like Lauterpacht, he had no news about the fate of his family. The indictment alleged that the Nazis conducted deliberate and systematic genocide, and the term came with his definition. On October the 18th, the indictment was formally filed at the Nuremberg Tribunal. I went to London. I succeeded in having inscribed the charge of genocide against the Nazi war criminals in Nuremberg. That was the way that Lemkin would later put it. The trial opened on November the 20th, 1945. Lauterpacht was present in the courtroom with the British team pushing for the protection of individuals. Lemkin remained in Washington with the Americans pushing for the protection of groups. One of the 22 men in the dock was Hans Frank, who is the fourth man in EastWest Street. He too was a lawyer, and from the 1920s, the late 1920s, he served as Adolf Hitler's personal lawyer in Germany, an early supporter of the National Socialist Party. In 1933, he became Bavarian Minister of Justice, and a couple of years later, at a conference in Berlin, he set out his credo at a legal conference. Community, he said, always takes precedence over the individualistic, liberalistic, atomizing tendencies of the egoism of the individual. Those words on that day generated thunderous applause. In his case, the words led to mass killing. In October 1939, he became Governor General of Nazi-occupied Poland, and in August 1942, he visited Lemberg and the district of Galicia, recently incorporated into his territory, the Government General. He hosted a concert. He brought a conductor who played Beethoven's Ninth Symphony. He gave a series of speeches in the course of which he announced the total elimination of the region's entire Jewish population. More than 500,000 people would be killed in the next months. Amongst those who were caught up in the horrors that followed in the days after Frank's visit were the families and friends and teachers of Lauterpacht and Lemkin, as well as my grandfather Leon's family. For each family, there would be only a single survivor, and in this way, Frank becomes the connector between the three men. He didn't seem unduly perturbed by such actions, more bothered by other mundanities. Those of you who've listened to my new podcast series, The Rat Line, will know that he worked closely with a man called Otto Wächter. And on the day he visited Lemberg, on the 1st of August 1942, he stayed with the Wächters. And Otto Wächter's son, Horst, shared with me his mother's diary. Frau Charlotte von Wächter described the day Frank came to Lemberg, how she played chess with him and how she beat him twice, and that made him very angry. He came downstairs and drove away immediately. 3 years later, in May 1945, Frank was caught by the American army near his home in Munich. With him were his diaries, 42 volumes, and a fantastic collection of artwork. When I say fantastic, I mean fantastic. It included this portrait of Cecilia Gallerani, lady with an ermine, painted by Leonardo da Vinci in the late 15th century. This painting hung in Frank's private office in the Wawel Castle in Krakow. Some of you will have seen it, as I did, when it hung in London a few years back at the National Gallery as a centrepiece. It's actually now back at the Wawel Castle in Krakow. I've come to know Frank's son, Nicholas, and he told me that when he was a young boy, his father would make him stand in his office before this painting and slick down his hair and part it like Cecilia Gallerani. Now, Frank was in the dock, accused, charged on a number of counts, including crimes against humanity and genocide. On the very first day of the trial, Frank's actions took centre stage. What happened in Lviv became part of the opening day of the trial. The prosecutors described acts of murder and torture on an unimaginable scale. They called it genocide. The Soviet prosecutors did, the Americans didn't. 130,000 people killed in that period, including tens of thousands of children murdered in just 2 months in the Janowska camp, right at the heart of the city. Pause for a moment. Lauterpacht is there, Lemkin is not, but he's reading the transcript. They don't know the fate of their families, nor do they know that the man they are prosecuting may have had a hand in the death of their own families. On this day, November the 20th, 1945, for the first time in history, the terms genocide and crimes against humanity are used in a court of law. I knew Lauterpacht and Frank to be in the courtroom on that day, and I wondered if there was a photograph of them. Lauterpacht's son, Eli Lauterpacht, who some of you will know, told me there was no photograph, but as with my mother and the 2 documents, I didn't believe him. I persisted in the hunt. And a friend introduced me to the archives of Getty Images, the largest collection of photographs from the opening day of the trial. I spent a long time going through hundreds of old glass plate images. Each had to be taken out of its protective paper sleeve. And finally, after hours and hours of looking, I found the image I was looking for. If you look very carefully, it's taken from an unusual angle in the courtroom. You will see Lauterpacht in the top left-hand corner. He's actually sitting at the British delegation table, hands clenched under his chin, attentive, directly behind Counsel's lectern, at which a Soviet prosecutor is speaking. If you turn your gaze to the lower right-hand corner, you will see the large, familiar figure of Hermann Goering in the oversized, light-coloured suit. If you move along the bench, you will see, 6 to his left, just before the image is cut off by the protruding balcony, the semi-bowed head of Frank. Divided by no more than a few tables and chairs, Lauterpacht and Frank together in the same room. The trial lasted for a full year. Judgment was given over 2 days, on September the 30th and October the 1st, 1946. You'll understand, I'm sure, my reluctance to avoid revealing everything that transpired over the course of a remarkable year, as the lives of the 3 men became increasingly intertwined. Suffice it to say that the connections were entirely unexpected. It was, frankly, a series of happenings which I can't describe better than the historian Anthony Beevor, of a kind that no novel could possibly ever match. The point that I'm making is that those 3 personal journeys coincided in ways that produced an outcome that would change the course of legal history and would then change history itself. The ideas and endeavours of Lauterpacht and Lemkin influenced politics, history, culture, my life, and your lives. The concepts they invented have entered our world, although most people seem to think they have existed forever. They haven't. Crimes against humanity and genocide are inventions, the product of creative and remarkable minds. 2 men driven by their own experiences, forged on the anvil of a single city. Quite why Lauterpacht opted for the protection of individuals and what caused Lemkin to embrace the protection of groups is, of course, a matter of speculation. Their backgrounds were similar. They studied at the same university. I found their student records and can tell you with certainty they had exactly the same teachers. If you trace the origins of these crimes, you can trace them to the city of Lviv, to events at the end of the First World War, and to the law faculty of that remarkable university. Indeed, you can even trace the origins to a teacher the two men had in common, Julius Makarewicz, a Polish professor of criminal law. You can follow the line to the building in which Makarewicz taught, and even to the classroom, which still today operates as a working classroom entirely unchanged from how it was when Lauterpacht and Lemkin sat in it 100 years earlier. There is something else that strikes me as remarkable. Despite their common origins, interests, and journeys, despite the fact that I was on occasion able to locate them in the same city on the same day, although never in Nuremberg, and certainly not in Courtroom 600, where they kept missing each other, sometimes by only a single day, it seems that Lauterpacht and Lemkin never actually met. But the concepts they put into international law inform my working life, and I've frequently wondered how it could be that I ended up doing what I do. My quest to understand Lauterpacht and Lemkin must surely have been driven in some way by my personal history and by stories that were buried away deep in family crypts, as described by the psychoanalysts Torok and Abraham, buried, no doubt, for the most protective of reasons. During the quest over several years, I conducted a lot more family detective work. I did manage to discover who Miss Tilney was and what she did, and I now understand why my mother and I and my brother have reason to be extraordinarily grateful to this remarkable human being, a missionary who worked for the Surrey Chapel in Norwich, England, where she was born, who was motivated entirely by the sermons of her pastor and remarkably by a single line of chapter 10, verse 1 of Paul's letter to the Romans. This single line, it seems, is what motivated her to travel to Vienna and save my mother's life in the summer of 1939 and the lives of many others of different religions who were persecuted by the Nazis. I also uncovered the identity of the man in the bow tie, and that was a journey that took me in different directions, first east and then west, across rivers and an ocean, and with the help of a pile of old Austrian telephone directories, hiring a fabulous private investigator in Vienna and ultimately sorting it out with Facebook, ended up in an attic in Massapequa, Long Island, in New York, from where there emerged this photograph, which would unlock another family mystery. A single image taken in the garden of a house owned by the Wittgenstein family on Brahmsplatz in Vienna in April 1941. My grandmother with two men in white socks, one of whom was the man in the bow tie and her lover. One discovery catalyzed another. The identity of this man, who was my grandmother's lover, led to another exploration and the identification of the man who most likely was my grandfather's true love, namely his best friend, Pax. Such efforts take years and years and years and involve the assistance of a range of remarkable individuals who helped, and I express my gratitude to them. These are the requirements of an exercise in personal archaeological enterprise. Perhaps even more remarkably and entirely unexpectedly, I learned of the more direct connections between my family and the Lauterpachts and the Lemkins. I was extremely surprised to learn what I had not known, that my great-grandmother, Amalia, was actually born and lived in the small town of Żółkiew, just close to Lviv, the same town where Hirsch Lauterpacht was born. Even more remarkably, The two of them were born and lived on the very same street, just a few hundred meters apart. It was called Lemberger Straße back then. Coincidentally, or perhaps not, Lauterpact's only son and child, Ellie Lauterpact, happened to be my first teacher of international law in 1982. He became my mentor. We worked together for more than 30 years at the university on cases, writing articles, engaging in other activities. But it was only in 2014 that we learned that we could share a connection to the very same street on which our ancestors had walked, a street that the great writer Joseph Roth called EastWest Street. In the course of the research, I learned more about my great-grandmother, Amalia. Her life began on the street of the Lauterpacts at the end of the 19th century. It ended on September the 23rd, 1942, in the kingdom of Hans Frank. The last street which she walked down was called Himmelfahrtstraße, the street to heaven, and it was the street that led from the railway platform to the gas chamber at a place called Treblinka. Exactly a month later, Lemkin's parents, Bella and Joseph, walked down the very same street and perished in the very same gas chamber. Amalia's life was caught, if you like, between the Lauterpacts and the Lemkins, as in a very different way is mine. How do you begin to understand and explain these points of connection? The starting point, of course, is the ideas of two remarkable men, Lauterpact and Lemkin, and the enduring relevance of their ideas today. The relationship between the individual and the group has been contested across the ages. I was very much reminded of this when I came across a letter written by Hirsch Lauterpact to his son Elie as he was preparing the closing arguments for the British Attorney General at Nuremberg at the end of July 1946. Lauterpact, the father, had recently learned that all but one member of his Lemberg family had been murdered on the direct orders of Hans Frank, remarkably the very man he was prosecuting. It must have been a time of extraordinary anguish, of personal grief, but also of professional challenge. To his son, he explained that he felt able to find solace and strength in music, and the music of Johann Sebastian Bach, and in particular of the Matthew Passion. Remarkably, at the very same moment, in the summer of 1946, Hans Frank told the American Army psychologist who was attending to his and the other defendants' needs, Dr. Gustav Gilbert, that in these most trying of times, as the trial reached its climax, he felt able to take refuge by imagining that he was listening to music, Johann Sebastian Bach and the Matthew Passion. How remarkable, I thought, that two men on opposite sides of the same courtroom would find solace in the same piece of music. I've come to understand the resonance of the work for Lauterpact, who was fluent in German. He knew the libretto. It reflected Bach's emphasis on the pietist belief of the role of the individual. Every aria but one in the Matthew Passion is sung as Ich, I, and the three landmark choruses are sung in the first person. What Bach was doing was signaling the bypassing of the group, the bypassing of the priest, celebrant, and the organized church, and allowing the individual to have a direct relationship with God. For Frank, with his scathing disregard of the integrity of the individual, the connection with Bach's Matthew Passion is more difficult to understand, not least since it is possible to understand the work as a scathing attack on the Catholic faith to which Frank had just converted a year earlier following a failed suicide attempt. Lauterpact believed that we had to concentrate on the protection of the individual, and he would surely argue even today that Lemkin's invention of the concept of genocide has been practically useless and politically dangerous. that it will replace the tyranny of the state with the tyranny of the group. And in a certain way, my own practical experience in international courts concords with that view. I've seen for myself how, by focusing on the protection of one group against another, there is a tendency, no more than that, a tendency to reinforce the sense of them and us, to amplify the power of group identity and association, which is a source both of sustenance and danger. How does this happen exactly? It happens because in seeking to prove a genocide, you have to establish the existence and expression of an intention to destroy a group in whole or in part. And I've seen for myself how that process, that evidentiary process, tends to reinforce both the sense of victimhood of the targeted group and hatred towards the perpetrators as a group. But of course, I also understand what Lemkin was trying to do, and he was surely right to recognize a reality that in most, if not all cases, mass atrocity is targeted not against individuals, not against people because of what they've done individually, but because they're a member of a group. Lemkin would say, and it's a powerful argument, that the law has to reflect that reality. It has to recognize and give legitimacy to a feeling that so many human beings have, perhaps all of us, of association with one or more groups. This profoundly strong sentiment was brought home to me very recently. I wrote an article for the Financial Times, a profile of a German psychologist, Dr. Jan Kisselhahn, who had established a program to help Yazidi women and girls who had been enslaved, tortured, and raped, enslaved, tortured, and raped by individuals associated with ISIS, Daesh. He established the program to bring 1,100 of these young women to Germany for medical and psychological treatment. In his work, Dr. Kisselhahn had identified a connection between the possibility of justice and the future well-being of victims. To characterize such atrocities as genocide was, for him, a vital first step, and he welcomed the use of the word in the European Parliament by the Obama administration and eventually by the Westminster Parliament. Calling it a genocide, he told me, recognizes the group's identity, recognizes what is being done to it as a group, and recognizes the group's right to exist. For him, crimes against humanity just isn't enough. It's not about individual rights alone. But I'm concerned about the hierarchy that seems to have emerged, one that puts genocide atop the list of horrors, so that a mere crime against humanity or a war crime is somehow seen as a lesser evil. If you call something a genocide, it'll be on page 1 of the newspapers. Call it a crime against humanity, if it makes it into the papers at all, it'll be on page 15 or some such thing. That is the power of the word genocide. That is the power of our association with groups. What, one might ask, then, is the enduring legacy of the two legal terms? After Nuremberg, there was a period of quiescence. 5 decades passed before the development of international criminal justice was prized open by events in former Yugoslavia, Rwanda, the arrest of Senator Pinochet, the creation of the ICC, the events of September the 11th, the actions that followed, taking us through Afghanistan and Iraq into the world of ISIS and Daesh, and the Yazidi women and girls of whom I've made mention. The crime of genocide and the idea that each of us as individuals has rights under international law were new, entirely new, in 1945. The moment of creation was significant, revolutionary, an act of recognition that the rights of sovereignty over human being and their exercise are not unlimited. But the killings have not stopped. And today, once again, there is a poison of xenophobia and nationalism and populism coursing its way through the veins of Europe and many other parts of the world. The strong man as leader is back. I've seen that on my journeys to central and eastern parts of our continent, in Hungary, in the Ukraine, where those who saw my film, My Nazi Legacy, will have seen me standing in a field watching people dressed in SS uniforms celebrating the creation of the Waffen-SS Galicia Division. I've seen it too in my journeys making the BBC series The Rat Line, travelling across Europe in Austria and Poland and other places. It's very hard to avoid what seems to be stirring and wondering to where it will all lead. The generation that has experienced the horrors of the 1930s, the generation that lived through the Second World War in Europe, the generation that knows why states came together after 1945 to create a United Nations, to adopt in Paris a Universal Declaration on Human Rights, to sign a convention on the prevention of genocide. That generation is about to be extinguished and gone. Perhaps the disappearance of actual memory, of actual experience, allows our politicians to take for granted what happened in 1945. It's impossible for me not to have gone through the experience of writing EastWest Street and the various projects that followed, an immersion of the world in the years between 1914 and 1945, and not feel an acute sense of anxiety about what is stirring. 2 years ago, candidate Donald Trump called for a total and complete shutdown for Muslims entering the United States. The idea of targeting people not because of their individual propensities, not because of what a person has actually done, but because he or she happens to be a member of a particular group, has a long, dark, and terrible history. The writer Primo Levi, who spent a year at Auschwitz, put the point most crisply in the preface to his book, If This Is a Man, published in 1947. He wrote, "Many people, many nations, can find themselves holding more or less wittingly that every stranger is an enemy. When this happens," he continued, "when the unspoken dogma becomes the major premise in a syllogism, then at the end of the chain there is inevitably the concentration camp. One thing leads to another." Against this background, the idea of a travel ban based on a person's nationality or religion is deeply troubling. Experience, recent experience, teaches us to know where such a beginning can lead, singling out people not for what they have done, but because they happen to be a member of a particular group. Closer to home, my home, I smell too change in the air, a strong move to identity politics. 2 years ago, the Prime Minister of the United Kingdom told her party conference, "If you believe that you are a citizen of the world, you are a citizen of nowhere." She has made clear her desire to take the United Kingdom out of the European Convention on Human Rights, if she possibly could. One former London mayor, Ken Livingstone, offensively evoked Adolf Hitler as a supporter of Zionism. Another former London mayor, Boris Johnson, suggested that the European Union and Adolf Hitler somehow shared common aims. Brexit and Trump are part of the same direction of travel. And so that's the context in which I oscillate between the views of Lauterpacht and Lemkin, between the individual and the group, between the realism, perhaps, of Lemkin and the idealism of Lauterpacht. I can see the force of both their arguments. I can recognize the tension and the struggle between the individual and the group, between crimes against humanity and genocide, between individual rights and group rights. It's not a tension that will soon be resolved. And that's why international law today embraces both concepts. But we are at a dangerous moment. Many of our politicians seem not to be able to recognize how precious was that settlement of 1945, that Universal Declaration of 1948. How vulnerable today is the acquis that has been created, one that has offered a foundation, not perfect, certainly, to international relations in our time. We cannot take for granted what was achieved back then. The threat to the multilateral global order and to the rights of individuals and groups is very real. That the challenge is now being led by the country that was the principal founder of that order, the United States, under President Donald Trump, is a matter of extraordinary concern. That countries like the United Kingdom choose to remain silent, mostly, devoured as it is by the short-term quest for possible future trade agreements in the aftermath of a likely but certainly not inevitable Brexit, concentrates the mind. Against that background, there are also positive developments. Efforts are underway, for example, at the UN International Law Commission, working here in Geneva, to prepare a new convention on the prevention and punishment of crimes against humanity, to fill a much-needed gap alongside the Genocide Convention. There is some new thinking, too, on how we can better enforce what we have. The events next Monday in Paris at the Palais de Chaillot to celebrate on December the 10th the adoption 70 years ago of the Universal Declaration and the signing of the Genocide Convention offer an important moment, a way of underscoring what the G7 just a few days ago somehow managed to put into their resolution, despite the objection of Messrs. Trump and Bolton. Guided by our shared values of the rule of law, how difficult it must have been for those two men to sign on to those words, and respect for human rights, even more difficult. We renew our commitment to promote a rules-based international order. I do not know how Trump and Bolton put their names to those words. All of this is the context in which I end EastWest Street, at a long-ago site of mass killing, standing at a mass grave, finding myself caught between different pools, between my head and my heart, between intellect and instinct, recognizing the need to value the inherent worth of every human being, but also understanding, too, that powerful pull of tribal loyalty and the essential truth of the notion that all of us is indeed haunted by the gaps left within us, by the secrets of others, but infused also by the possibility that the mere discovery of such a haunting will not necessarily destroy us, but could actually make us stronger. Thank you.
Thank you very much, Philippe, for this presentation. I had already the pleasure to listen to part of it a few years ago at the University of Geneva, but it was a pleasure to listen to it again. And many questions can be asked. I would like to ask you a few of them, but I give the floor first to the audience for questions or comments. We have 20 minutes about. We have a light just here, so it's...
There's a mic coming.
Yeah, okay. Professor Sands, we've met, and I've met your wife, Bertie Rumthorne from Guyana, but you saved a little bit before the court. I listened to you with much feeling, and I thank you for this. And I want to say the following to you, if I may. A Swedish writer, Hans Ingvar Roth, has just published a book on P.C. Chang and the drafting of the Universal Declaration of Human Rights. And P.C. Chang probably was the most important drafter of the Universal Declaration. And P.C. Chang insisted on the intercultural dimensions of the Universal Declaration. He insisted on the secularization of the Universal Declaration. P.C. Chang put before the drafters the idea that there is an aspect to human beings that is bad, and there is an aspect of human beings that is good. And the mission of the Universal Declaration is to humanize humanity. So now, I make these comments for the following reason. As I listen to you, I've studied Lemkin, I've studied Lauterbach, and I have much feeling for both of these gentlemen. And as I listen to you, my thoughts are, as you know, I have a long background in the field of human rights. As I listen to you, I find myself thinking the following. The great powers that are challenging the international normative edifice, they include not only the United States, but China and Russia. John Mearsheimer, a political scientist, has just written a book called A Grand Illusion. And he argues that for the great powers, rights don't really matter. And so as lawyers, we have to come to terms with this political science dimension. That's my first point. Secondly, as we take this cause forward in the international community, we have to keep in mind a certain pushback, not only from these great powers, but from many of the countries that we see around the world. So my point here is, I don't have a question to ask you. I just thought out of the richness of your presentation that I should put before you B.C. Chang, so that we have this wonderful story of Lauterbach, and we have this wonderful story of Lemkin. We also have the wonderful story of B.C. Chang. And by the way, B.C. Chang died in misery in America because the communist regime had changed, taken over, and his ideas, let's just say, now you know what is happening in China. So now, to conclude, as a comment, dear Professor, thank you. But I think we have to enlarge this discussion. And I think we have to put B.C. Chang into the picture. Thank you very much.
Okay, let's collect more questions or comments, please. So the lady towards the last row.
Thank you, Professor, for this fascinating talk. I read with great interest your book. I come originally from Lviv, and I was surprised that you paid little attention in your book to the Jewish, Polish, and Ukrainian relations. I would be interested to know more your thoughts about this triangle history. You mentioned that there are some good examples of cooperation, but what was the reasons that led to the Holocaust in that case? And another question is related to the use of genocide today. What is your opinion to the recognition of Ukrainian Holodomor as a genocide, as a form of the starvation as a form of genocide, as an artificial starvation? Thank you.
Maybe I'll just take very briefly, just respond to these. Firstly, very nice to see you, Bertie. It's been many years. You're absolutely right, and I don't claim in any way that this is the complete story. It's one set of stories, and it sheds some light. And absolutely, but there are. I think one of the things that EastWest Street has helped, in particular students, to realise and do is that how international law is made, how it's applied, is much more complex than just courts or states mechanically doing what they do. Behind all of these social constructs are individual human beings who influence things in different directions. And if that creates a better reflection on the P.C. Changs and the René Cassins and the Eleanor Roosevelts of the world, that's a great thing. I should say, I learned that, as I hinted at in the lecture, from sitting in a courtroom, particularly the ICJ, and realizing that outcomes, judgments, have very little to do with the law and very much more to do with the individual propensities of the individuals who happen to be sitting up there and the individual propensities of the people who argue the cases. And that's a very big root of it. In relation to Lviv, I mean, again, I do give a bit of background, but it's not a history book in a certain sense. I'm not a historian. I can't possibly do what historians, and there is some incredible writing on Lviv, Lvov, Lemberg, Leopolis, call it what you will, in the inter-war years. It's so rich. I would take this in a slightly different way, and I would ask this question. I can imagine what it was like now. I've spent so much time in that city. I've read so much. I've watched movies, I've read books, I've wandered the streets. No one in that city in the 1920s could have imagined what was going to come. You had 3 communities living together, more or less, in roughly equal numbers. Ukrainians, who were called Ruthenians back then, Poles, and Jews. The Poles were the privileged community. The Jews were discriminated against, but not as much as the Ruthenians. And you see that in the student records. It's very, very interesting, because each student had to write what their nationality was, and you see a great number of Poles, rather less Jews, and almost no Ruthenians, as they would put it, because they really weren't allowed to go to the university, and certainly not the law faculty. But I don't think any of the communities could have imagined that within 25 years, one of the groups would have been physically exterminated, and the other group would have been physically expelled, so that those left were essentially what today are called the Ukrainians, inhabiting a space that was largely built by others, if you talk about the central bit of that incredible and beautiful city. But as I mentioned in the book, what's really interesting, every time I go to Lviv, someone will come up to me and say, oh, the story you're telling touches me very personally. They won't say I'm Polish or I'm Jewish, because it's not cool still in Lviv to say that. It will expose you to difficulties, which is why I appreciate very much that the very courageous mayor of Lviv, Andrzej Sadowy, has put up plaques to honor Lauterpacht and Lemkin, who are both Polish and Jewish, in very public places. And I think it marks a re-engagement publicly in discourse with that history. But of course, the big question that I ask myself is, could it happen in a place like London? We just take for granted that we live in these fantastic multicultural cities with lots of communities living together. But why not? Why could we not have a change in the UK in which 25 years from now, if one takes Brexit, the move against immigrants, the creating of a hostile environment, which is what is going on, to its logical extreme, it actually leads to people being thrown out. It actually leads to a sort of cleansing project. And you can begin to see. I'm very careful. I have kids, who are growing up. I don't want to go around doom-mongering and scaremongering and, oh, it's all happening again. Blah. That's not what I think. History is much more complicated than that. What I'm simply saying is we can't take it for granted. We cannot take the acquis of 1945, a tiny moment in human history, for granted. In relation to the Holodomor, as you know, Lemkin is now banned in Russia because he treats the Holodomor rightly, in my view, as a genocide within his definition, which is a different definition from the Genocide Convention. He has the bar much, much lower than the Genocide Convention. But for him, that was absolutely part of his acts of horror that he included in his definition of genocide. And because he did that, his books are banned in Russia. I was pretty surprised that EastWest Street was bought this year by a Russian publisher. And I'm wondering what they're going to do when they get to the many bits about Lemkin. But nothing surprises me, I suppose, these days, because the book is also about to come out in Chinese. And I think in China, I'm sort of a banned person because I was lead counsel for Philippines against China in the South China Seas case. As one Chinese friend told me from Beijing, that they probably haven't made the connection. They think there are two Philippe Sandses. There's the terrible one who does the cases against China at the Permanent Court of Arbitration, and then there's the good one who writes these books that we can try to publish. But your questions are important questions.
Thank you very much. Can I take the privilege of the floor just to ask you one very simple question? I guess that you have received this question many times. Why do you speak of a tension between the individual and the group? Now, the two can coexist, and I understand that at a personal level, we are both. I mean, we are individuals, but we have our own history, which is very much also linked to which group we belong to and our collective dimension is part of our individual identity. So why do you see it as a tension? This is, I mean, also in the crimes against humanity, let's say, definition, okay, I understand that it is not formulated in terms of protection of groups as such, but still there is room for persecution as a crime against humanity. And even in the human rights discourse, self-determination of people is one fundamental, let's say, human right. So how do you see it as a tension?
I see it as a tension largely, I think, because of the work that I've done in doing cases on genocide and this terrible feeling that you get when you're sitting in a room marshalling the evidence and you'll say to a foreign minister or a president or a prime minister, look, I'm really sorry, but the evidence doesn't cross the threshold of genocide in international law, and you'll then have a whole conversation about it, and typically the response will be, okay, we're going to get more evidence, and it involves things like going and getting films of horrible acts of killing, which you then have to sit through and watch, sometimes while being made to eat pizza, incredibly. And they'll then say, well, look, you know, look, that person, when he was cutting that person's head off, was saying, I'm killing you because you're X or Y. Why is that not genocidal? And so I've seen for myself that the need to prove that intention to destroy a group in whole or in part has a psychological aspect that reinforces the sense of self-identity. They've done this to us. They are terrible people. We are victims. There will be a price to pay in years to come for the fact that Bosnian Muslims got a genocide at Srebrenica and Croats at Vukovar only got a crime against humanity. And I'm doing no more than asking the question, why do we need both concepts? What is the social function of having both contexts? I can just explain that in another way. Every year around the world, there's a day that is referred to in different places as sort of International Holocaust Memorial Day, and I was called in to a sort of academic advisory board in London a couple of years ago for a meeting to discuss the way forward on these things. And in Britain, the way that it's done is International Holocaust Memorial Day is used to mark other acts of mass atrocity, quite rightly, in my view. And I asked rather innocently, how do you choose? I mean, there are so many. How do you choose what you're going to mark? And they said, oh, very simple. We have a Foreign Office formula. It's sort of killer words the moment you hear that. I said, oh yeah, what's the Foreign Office formula? They said, well, first thing, it has to be after 1945. Very convenient. Colonialism's out. Turkey's out. You know, and so we've got, you know, and then the second condition is an international court or tribunal must have ruled that a genocide has been committed. Ah, I said, so you will commemorate the killing, the terrible killing of 8,000 people at Srebrenica, but you will pass in silence on the killing of 3 million people in the Democratic Republic of Congo at exactly the same point. Exactly, they said, you've understood it. So why is that a good thing to do? Why is that useful to create hierarchies of victimization in which certain groups are given an elevated status and on others you pass in silence? So I'm torn. On the one hand, I really recognize what Lauter Pact was trying to do. Focus on individuals as human beings. It doesn't matter whether they're Congolese, Palestinian, Jewish, Muslim, Christian, atheist. Killing tens of thousands of people is a bad thing. Is killing them because they're a member of a group with the intention to destroy a group so much a worse thing that we have to treat those people differently? So that's the argument in favor of Lauter Pact. On the other hand, the reality is probably for everyone in this room, in different ways, we feel a sense of kinship and connection. When I'm standing in Zhulkiev, at a mass grave in which 3,500 people are buried still today, unmarked, Lauter Pact's family, my grandfather's family, and they're only there because they happen to be the wrong religion at the wrong moment, in the wrong place, the wrong time, you feel a sense of connection. And I find that, on the one hand, deeply troubling. I feel connected to those people because they're part of my family. They're part of a group that I'm a member of. I'm a member of many groups. You know, I'm white, I'm male, I'm heterosexual, I'm an Arsenal supporter, I'm English, I'm French.
An international lawyer.
I'm an international lawyer. So many different groups. But it is a tension. It is a tension. And I think for each of us it raises the fundamental question, how do I want to be protected? How do I want to be defined? Do I want to be defined as a person whose life is valuable because I'm a living, breathing human being? Or do I want to be defined and protected because I happen to be a member of a group? And there's no simple answer to it. I don't go one way or the other. I oscillate madly. And the moment you put the question in those ways, I think it becomes much easier to see why there is a tension. And one of the things that's made me really happy with this book is that it takes a sort of arcane, curious set of legal definitions and teases out of it complexities that every human being understands. So why do I get invited to India, South Africa, Mexico, and 25 other countries around the world, which has nothing to do with Poles and Ukrainians and Jews and Germans, and they want to talk about this? Because it touches everyone, everywhere. It is a completely universal theme. And so the book just becomes a vehicle for exploring a much bigger issue about identity and who we are. And there is nothing original about the book. I take no credit for doing anything original. If you go back to Bach, that is what Bach was doing. 300 years ago, Bach was dealing with the same issue. And it's a constant as human beings.
Thank you very much. So we have another question over there.
Thank you very much for this wonderful presentation. I would like to rebound on the tension between the group and the individual, because I think in your book you give a very nice example of that when you basically tell the story of an encounter with a Polish scholar that was an expert of Julius Macavrit, and you asked him about what was the opinion of Macavrit about the minority treaties, and he said that he detested them because it discriminated against the Poles. So the minority treaties somehow gave a kind of privilege to a certain category of the population and didn't cover the rest, or it was not a universal provision. And so that tension between the collective and the individual somehow was there. And my comment, or rather a question, is when you say that Lauterpacht wanted to protect the individual, it's true also that in his International Bill of Rights, he included a provision for minorities. And he said it would not be justiciable, but he included that because I think he understood that although it would be better to avoid the excesses that the Nazis somehow had shown would be possible on the basis of a group right or a group understanding of identity, it would be necessary to inject some provisions in order to protect groups. And so I was wondering whether somehow this vision of Lauterpacht and Lemkin as very far apart somehow is not contradicted, but to some extent Lauterpacht understood that Lemkin was right to some extent by trying to include this article in the declaration, and in the end it was not included, but he really he wanted it to be included. Thank you.
Yeah, no, I mean, you're absolutely right, and there are shades of complexity. Lemkin was not against individual rights, but he thought they were just not enough. And Lemkin was not against some group rights, but he worried if they were taken too far. He was totally against Lemkin's genocide project. And if you read the editions of Oppenheim that he edited, you'll find some of his rather scathing comments about the Genocide Convention and the dangers that it would lead to. But one of the things about both men was that they were not purists. They were advocates and they were strategists. And they used advocacy and strategy. So I mentioned, Lauterpacht has nothing to say about what we today call African Americans, but which he would then have called blacks, or as he did, Negroes. Because he knew that if he said those human beings had individual rights, he would undermine his project with the United States. And it raises a question that many of us have faced. You know, the best is the enemy of the good. Do we make a little bit of incremental progress, grit our teeth, and hope that it'll be okay, or do we take an absolutely pure direction? And I don't begrudge either of the two of them, that you can attack the logic of their positions by reference to their own writings. They both lived in the real world, and they both had a project. They both lobbied madly in very different ways, and they both had an agenda. And it's just normal part of human life that they took that agenda forward, and that meant making compromises. It was very striking for me that I came across the individual and the group thing completely by accident. I mean, the person who got me invited to Lviv is sitting here in the audience. She remembers the first time we had a conversation in 2010, and she said she came from Lviv, and I said, oh, Lviv, yeah. I think my grandfather was born there. I'd love to go there one day. And she procured the invitation. And I just toddled off. I didn't intend to write a book. I didn't intend to think about individuals and groups. It was completely an accidental project. And then once I'd stumbled into it, it just kept popping up everywhere. So, for example, you get those wonderful exchanges when dear Hans Frank, or not so dear Hans Frank, the only defendant in the trial who came close to accepting responsibility, goes only so far as to accept his responsibility as a member of the group. Okay? He says, I was part of the system committed crimes, therefore I'm responsible. And in the luncheon room at lunchtime after he's done that, all the other defendants, led by Hermann Goering, come down on him like a ton of bricks and say, no, you cannot do that. We are not all responsible as members of groups. You are individually responsible, perhaps, and don't you dare say you're individually responsible, because then they'll find we're individually responsible. And he retracts because they've clobbered him, basically. He retracts 6 months after making his acceptance of responsibility. He retracts it under pressure on the individual group thing. And once you begin to look at things through that prism, you can see it in many different aspects in that book, but in many different aspects in life. I mean, to be honest, there are so many things I didn't realize I was writing as I was writing the book, and even when it was published. And I went to a seminar very early on at Cambridge with two fantastic historians, and they told me all these things that the book was about that it was fantastic. I had no idea that it was about silence, and they found 47 examples of silence in the book from all different sorts of people, and I just thought, you know, it's really interesting how different people read the same thing and find different things. But there's no contradiction, I think. The gravamen of where they were going was in those directions, but absolutely they were not absolutists. And of course, you know, Lauterpacht, you know, made a lot of concessions. If you read his International Bill of Rights, man, I mean, he says human rights are part of natural law, which he totally didn't believe. But he knew he had to do that to basically knock off some of the opposition. So he was not a purist scholar in the sense that he took things intellectually in the direction that he wanted. He, like Lemkin, had an agenda, but they implemented their agendas in different ways. And I don't begrudge them that for a single moment.
Thank you. We take a last question from Professor Sassoli.
Thank you very much. It's always inspiring to hear you, and I agree that there is a fascinating tension between the rights of the individual and the rights of the group. Sorry, Paola. My question is whether you think to, as you did it, to link it with individuals involved adds to our understanding, or simply, not simply, no, it's very important, illustrates and disseminates this, and there you did an incredible work, because 100,000 people would never have read a book about the conceptual problem, while with the grandmother and Lemkin and Lauterpacht and so on, this is what 100,000 people read. Or do you think this adds to our understanding of this tension? Thank you.
I think it depends what you mean by the word our, and in what capacity you're speaking. Are you speaking as a scholar? Are you speaking as a lawyer? Are you speaking as a human being? And I think the answer is different. And as you will know, part of the project that I've been involved in, again accidentally now for 15 years, is to break down the barriers of the community that engages with international law. Because I fear that we, and it's not a critique of anyone in this room, it's a critique of myself, spend or have spent too much time talking to ourselves. And we have zero clout, virtually, as a community. And beginning with the Iraq War, that's really what started it. I, and others, and I'm certainly not unique in it, had a sense that we needed to find a way to reach out and touch people who are not lawyers, who are not international lawyers, but who are smart, intelligent people who read, who think, who care about the world, who care about their lives, and get them thinking about these issues. So do I think I've improved the understanding of the international law community? Totally not. I wouldn't presume to say that. There's many people in this room who've gone far more deeply and far more rigorously into these issues than I have. But do I think I've changed the understanding of le grand public? Absolutely. I get dozens of letters every week from all over the world, from people who have no background in international law, who all of a sudden have become interested in what happened in 1945. The Universal Declaration, I mean, we're here for this wonderful seminar today on the Universal Declaration, and people they write and they say, I had no idea about the differences between crimes against humanity and genocide. I thought it was the same thing. I had no idea. I thought they had existed forever, these concepts. I didn't realize they were invented so recently. And so for me, the indicia of making a difference, if that's the test, helping our understanding, is getting more people to think about these issues. Not to impose my view or to say that I'm right or wrong. There are lots of different views that are possible, but to think about it and begin to bat for what happened in 1945. Reasonable people will have different views about the merits and the demerits. So in a sense, I'm turning your question around and saying, what was my agenda? And my agenda, explicitly, a different form of advocacy from Lauterpacht's and Lemkin's, was to reach a global audience, to touch people who we need on side if we're going to protect the value system that I, and I think most people in this room, care about. We cannot just talk to ourselves. We've got to go beyond our community, and we've got to link with other communities. And there, I think it is plain that it has made a difference. I mean, some of you know, I do using the Bach theme with two musicians, I've created a piece that links words and music. And we only do 4 performances a year because we love doing it. It's me, a German actress who's incredibly famous in Germany to the point that you can't be in the street with her because kids mob her. And, you know, she's been in famous kids' films with great titles like Fuck You, Gaeta, which has made her, she's a wonderful person, Katja Riemann, a very famous French opera singer, Laurent Laourie, a wonderful jazz and classical pianist, Guillaume de Chassis, and we just do it 4 times a year. So then someone said, oh, why don't you come on tour to Australia? And we were like, well, yeah, great, if you want to pay for us to come to Australia, you know, we'll come, but who's going to come and see this? It was astonishing. audiences of 2,000 people, okay? Come to spend 80 minutes being told stories about international law. And I love that. I love that there are people out there who care about these things and want to do it. And I think that is what makes a difference. For me, the international law community is on board. There'll be reasonable issues to do on minorities and individuals and that's incredibly important. I'm nourished by spending 25 years of doing that kind of research. You have to do that to be able to get to the point that I've got to, I think. But I want to touch a different audience, and that's the audience that matters, and that's the audience that I care about, precisely because, as I said in the lecture, I think the settlement of 45 is under threat. Trump is not a madman. Trump has an agenda, and the agenda is to destroy the global rules-based order, which is what makes the G7 meeting of last week so entertaining in a sense, because the agenda is to destroy and to replace the multilateral system with a bilateral order. So I think we have to get off our asses as international lawyers, and if we're going to defend it, we've got to get out there and we have to militate to defend it. And if we're going to militate to defend it, it means we've got to engage with a much bigger audience to talk about, you know, what these values and what these issues are. And I saw that in Britain in Brexit. We saw what happened. The EU is flawed in many, many respects. The European Court of Justice is horrible in many, many respects, but it's better than the alternative. And the politicians in Britain did not address the rationale in 1950 for what was created. People have forgotten. Belatedly, actually, people are now coming back to it. And remarkably, Northern Ireland is what's causing people to realize, actually, we really care about peace. It's not so easy. We need to do things and put things in place. But the debate was completely absent in 2016. No one talked about that. No one focused on the rationale. And I think we've got a piece of work to do, and that's the way I would answer the question. And to get people focused, they need individual human stories. They don't need legal theories. They don't need judgments. They don't need cases. They don't need treaties. They need individual human stories about remarkable human beings and dastardly human beings. And once you've opened that door and, you know, collected characters like Frank and Miss Tilney and Lauterpacht and Lemkin, and they've opened that door, they read about the international law stuff. My dad, who's a dentist, said it was really interesting, son. Really interesting. I had no idea. So I had no idea about all this stuff. It's really interesting. It was, and readable and interesting. So that was the test for me. And that's not for a moment to say, for scholars in the room, for students, for PhD students who are becoming scholars, that what you're doing is not immensely valuable. It is immensely valuable. But while we're doing it, we've also got to look over our shoulders and see what's going on. I think it's a very dangerous moment right now.
Thank you very much. You are certainly among the exceptional men. As I said, you are among the exceptional men who can do what you are doing, actually. So we hope that we be able to follow your example in the way we can. I don't know how to sing. I would like to come with you, you know, or whatever. But in any case, thank you very much for your presentation and for the very stimulating reflection for today. Thank you so much.